before this committee with respect to which there is a conflict of interest. If you have a conflict of interest, please let us know. We can instruct you from there. If you're not sure if you have a conflict, just come up and raise your hand or ask us and we will address it from there. So welcome everyone. We had an orientation before where Brian did an exceptional job in about 26 minutes of orienting all the new members of everything they need to know about this committee. But we're going to go ahead and jump in today and start with the special agenda items. And as far as administrative, where is Ann? Yes, if you will provide us with a report on the trust account audits that you did in the last quarter. And if you'll also tell us what districts you went to.
So the audits for the last quarter, fourth quarter 2022, were conducted in judicial districts 12 and 22. District 12 was previously audited in 2017. District 22 was previously audited in 2018. I conducted 27 audits in District 12 and 12 audits in District 22. The two most common rule violations were that 43% failed to maintain clear check images or maintain them in the required format, and 25% failed to escheat unidentified or abandoned funds as required. Audits for the next quarter will be in Judicial District 1, composed of Camden, Chowan, Currituck, Dare, Gates, Pasquotank, and Perk Women's counties, Outer Banks, and Judicial District 31, composed of Forsyth County. Any questions?
I actually have one. You never get questions. I have a question. Marcy and Wade and I were at a meeting recently where one of the attorneys who's been around forever was going pretty much nuts about the fact that if you pay things electronically, you have no check image to maintain for state bar purposes. And there was conversations between him and the younger folks who do that routinely, who told him how to go about doing it. But I didn't know what they were talking about. So when we have old people who ask us, now that if I'm paying things electronically, I don't have a check image, how do I get one? What do we tell them?
So when you say pay things electronically, you mean online transfer?
Yes, ma'am.
Okay, so you should retain a confirmation of that transfer. And when you're processing that transfer, the client identification has to be indicated on that transfer somewhere.
Okay.
So sometimes when you say you're processing an online transfer and you get confirmed, that's all there's nothing else that you get. So you really need to print that screen before you get confirmed.
Okay.
And so that is your proof of the transaction.
So the state bar's position is a confirmation of transfer equals a check image?
Yes.
Okay.
Correct.
Thank you.
I've got a question for you. I think I read the material that Alice shared with our new counselors that as new counselors, your trust account is audited. So what quarter will that take place?
Asking for
That was definitely in the fine print, something that's not very clearly advertised. Yes.
So what I do is it's all really logistics, depending on where the new counselors are. I think most of them actually, fortunately for me, are within, maybe not for the counselors, within the first quarter area that I'm auditing. So I can work them in with my regular random audits. So probably between now and the end of April.
They'll be excited to hear that.
I'll give you a good heads up.
I think, Ann, we have another question. Wade?
Okay.
Would you send some sort of advance, like a form or something for us to fill out so that we can know what information to get together for you?
Yes, I actually have an audit guide sheet that every lawyer that is being audited receives, and it lists reference materials like what are the rules, the Lawyer's Trust Account Handbook section about random audits, and it lists the records to have prepared for them.
And so if you are in judicial district or near judicial district 1 or 31, you're probably going to get some people complaining. So if you have questions about the last time they were audited or other things that you get asked, please make sure to ask so that you can answer those questions for your constituents. Yes, Madam President.
And the other thing is tell your districts that the Issues Committee of the State Bar is now looking at the random audit process to make sure that it makes sense in today's world, since we have not looked at that process for 30 years. And Ann truly believes it needs to be looked at, and everybody, I think, on the Issues Committee believes it needs to be looked at. So if they start complaining and whining and moaning, that they've been audited more than the person down the street or whatever, you can just tell them that the State Bar is studying our random selection process.
Thank you. Thank you for your work.
Hey, Heather, is anyone else having trouble with the Wi-Fi? Is that why Peter's hiding?
Yes.
We're having an issue with Wi-Fi with the number of devices, and I think so. If you're on both your phone and your computer with the Wi-Fi, and you're not using your phone, if you would consider turning off the Wi-Fi on your phone, that we're hitting a max number. So I'm getting the staff to do it, and we're working on other solutions too. But anybody who wasn't on earlier this morning trying to get on now is probably causing issues. I'll update you as soon as I have something new on it.
All right, next we're going to be with Suzanne. She's going to give us a report on the ethics phone calls during the prior quarter.
So one of the things I do is I keep track of the number of inquiries that Nicole and Brian and I answer each quarter. And last quarter we answered 946 inquiries, and that's pretty typical for the prior quarter. In fact, I like to go back and see what the averages are for previous years. And the average for the past 5 years for this quarter was 946 calls.
Wow.
So we were right on the money.
Thank you. So next we're going to hear from Brian about a report on the CLE ethics presentations completed in the last quarter.
Right, and you can see in your materials a list of the ethics presentations that we've done. The big message here is that we want to be available to you all, your organizations that you're a part of, your district bars. If you want to put something together and you need an ethics hour, feel free to give us a call. Because again, this is an opportunity for folks to see staff come out there. We can hopefully, teach you something new, or maybe just clarify some of those questions. But I think there's, as we all know, the general impression of the State Bar, there's always the expectation that, well, the State Bar is only about discipline. But we're more than that. We want to walk alongside lawyers to make sure that they stay in the correct lane for the protection of the public. And so sometimes when we go out there, we can hopefully change some hearts and minds just to know that we're out here and we're a resource to you. You can give us a call for ethics advice. So feel free to reach out to us. But you see the 9 different presentations that are in your materials.
One note on that, we had talked about this in the orientation, is that all of you, as some of you know, will be the de facto go-to for people in your area when they have an ethics question. When they find out you're on the committee, that you are now the expert. You may or may not be the expert in your humble opinion, but remember that you can contact Brian. And Nancy Grace, one of our new members, actually just had this happen yesterday and perfectly got the person in touch with Brian, and he, in the midst of everything else he was doing, picked up the phone and walked the person through the issue. And so they're very serious about that. So if you get questions, please direct them, make sure they have the connection, because you'll be amazed how many people have no idea. We have a hotline, no idea.
Yeah.
So make sure to keep that number available in the email address so that you can pass that on. Next, we're going to go to the rule amendments, and I'm going to ask Brian to talk about the rule amendments that were approved in the prior quarter by the Supreme Court.
Yeah, this is an agenda item that we haven't previously put on, but I realized we probably need to do this. Make sure that you all are aware when something gets approved by the Supreme Court. Those of you that were on the committee last year remember that particularly early on in the year, the Ethics Committee recommended and the State Bar Council agreed to publish some proposed amendments to the rules dealing with confidentiality of information. Particularly, this was stemming from the inquiry, which we'll discuss shortly, the inquiry about whether or not a lawyer can speak publicly about the public aspects of a client's case. Under the old Rule 1.6 and 1.9, a lawyer was prohibited from doing that because the duty of confidentiality is very broad, and that duty encompasses keeping confidential all information acquired during the representation. The original opinion that we published said that you cannot speak even about the public stuff that occurs without client consent. And that was an opinion taken by a number of different jurisdictions as well as the ABA. Our opinion that we published got a lot of comment, a lot of feedback, and it ultimately resulted in us looking at the rule and realizing that the rule really needed to be reevaluated to address the practical realities of practice, as well as addressing what harm we're considering here, and if the public really is, I guess, if they have the expectation that lawyers can't talk about what happened in a public hearing. So ultimately, we have these rule amendments, Rule 1.6 and 1.9, and so just so you all know, you have the materials, so you have, or in your materials, you have the actual approved versions of 1.9. 1.9 does allow a lawyer to speak about former clients' information if that information is in the public record, was publicly disclosed at a hearing or a public hearing, or was otherwise publicly disseminated, as long as the disclosure is not detrimental to the client. So that's an informational item to you all that was approved by the Supreme Court November 2nd. So that is the new rule here in North Carolina. The other rule that was approved by the Supreme Court in November was our amendment to Rule 1.19 on sexual conduct with clients, because the old rule only addressed sexual relations, physical contact with clients, and now the rule prohibits both physical interaction with clients as well as sexual communications. So the rule, again, is in your materials. This is now the rule in North Carolina, and I do believe that North Carolina is the first jurisdiction to officially prohibit sexting. I was going to use other descriptive words, but we'll just, since we're live streaming. Yeah, sorry, Catherine's mom, sorry. But yeah, so take a look at it. But it's something, and I'll have to say, I shared this with other ethics counsel. There's an email of a bunch of nerds from across the country that are all the ethics counsel in these other jurisdictions, and I sent this out. I know one jurisdiction responded back immediately saying, this is really interesting, I'm going to pass this along to some of our folks. And I believe Carmen Bannon from the Office of Counsel, she worked on this rule amendment, and she has proposed a presentation at a National Organization of Bar Council on this particular rule amendment that somehow she's roping me into potentially. So we'll see how that happens. But we're trying to, again, do relevant things with the rules of professional conduct. I think we did just that in these amendments, but they are in your materials, and spread the word. There are some new rules for lawyers to know about. Warren.
The Supreme Court remains silent on the amendment to the preamble.
We have not received a response yet.
So Brian said it perfectly. As far as those rules and those changes, it usually takes about a year to 18 months for it to trickle out to everyone. And so be familiar, keep it handy, because you're going to have somebody call you in 6 months and not understand or ask questions. And it may not be on your radar because you're now into other issues. But as your constituents or on listservs, you hear about it, people asking questions, I would just keep these rules handy, because these will be ones that, especially for family lawyers, may come across and be common questions. So next we're going to go into one of our subcommittees, and this is the consideration of an amendment to Rule 1.8E, which is conflict of interest, current clients, specific rules. And so I'm going to hand it over to Nicole to get us up to speed on what's been going on.
Yes, so a subcommittee was formed to look at Rule 1.8E, which is the rule that prohibits lawyers from providing financial assistance to clients when they're in connection with pending or contemplated litigation. To add whether or not we should add a humanitarian exception that would allow lawyers to provide gifts, modest gifts to clients. The general prohibition against providing financial assistance to a client stems from generally being construed as forbidding gifts or advances to clients for living expenses, even if it is for humanitarian purposes. Historically, the primary purpose against these kinds of gifts was to guard against champerty and maintenance. In 2020, the ABA looked at revising their rule, the model rule, to include a humanitarian exception that would allow lawyers to provide modest gifts to indigent clients in pro bono cases for basic living expenses, so things like their rent, food, transportation, basic living needs, that lawyers could do that. However, the model rule only allows certain lawyers to do that. So lawyers who are working for nonprofit legal services like a legal aid, public interest organizations, law school clinics are included in the exception that allows those types of lawyers who are providing legal services for free to indigent clients. There are some restrictions in the model rule, however. The model rule does not allow lawyers to promise, to assure, or imply the availability of such gifts. You also can't use that as a mechanism to avoid being discharged or fired by the client by telling them that if they fire you, then the money stops. The rule also restricts and says that lawyers may not seek or accept reimbursement from the client's family, or any third party related to the client. So you can't make the gift and then ask for reimbursement later. It's supposed to be a true gift. And lastly, you can't publicize it. You can't advertise or include in your advertisement to prospective clients that you are willing to provide such gifts. The subcommittee met, and the consensus of the subcommittee was that the historical purposes to avoid championing and maintenance are really obsolete and outdated, and that's not a good reason to avoid allowing lawyers to provide a humanitarian gift to their clients.
Can we pause and ask anybody, does anybody know what championing and maintenance is?
Actually defending that claim right now on behalf of a lawyer.
Oh, fantastic.
I see also accompanied by a claim for Baratrip.
Ah.
For that too.
I remember the word.
Partridge in a pear tree.
Championing, oh, and that's to those that did not raise their hand, championing and maintenance, you wanna
No.
real quick?
Because our subcommittee said it's not necessary.
It's getting a financial interest in the pending litigation or
Right.
stirring up unnecessary litigation. But yeah, we like to use those terms, especially when we live stream.
So the subcommittee talked about whether or not, they talked about that humanitarian exception would be good because it would assist their clients in avoiding accepting lowball settlement offers out of desperation because they need money, or to getting high interest loans in order to pay for their basic living expenses while their matter is pending. The subcommittee also discussed whether or not the North Carolina rule should be expanded to include lawyers who work on a contingency fee basis, because some of those clients are indigent. They don't have the funds to be able to provide their basic living expenses, especially if they're injured. So this would come up a lot in like workers' comp cases where the client is not able to work because they're so injured, so which means they don't have an income, or their income has been halved because only the spouse is working. So those people could be in need of a humanitarian gift from their lawyer. The subcommittee also discussed whether or not our rule should allow for exception to apply to lawyers who are court appointed because they get low fees. They talked about the fact that not all pro bono clients are indigent, so maybe our rule should say pro bono or indigent. Ultimately, they decided that that is what they would like the rule to read, that lawyers, not only the lawyers that are included in the ABA exception, so like the legal aid lawyers and those types of lawyers, but also that any court-appointed lawyer would be allowed to provide humanitarian gifts, and any lawyer that was providing pro bono or indigent, representing clients on a pro bono or indigent basis. They ultimately decided at this time they would not include contingency fee lawyers, so PI, workers' comp, MedMal, those types of lawyers would not be included in the rule, but that maybe we would discuss that later down the line. So the staff directed that I draft a proposed rule that includes all of those things. So it'll look a lot like the ABA model rule, but with a few tweaks that we would allow for court-appointed lawyers that the ABA rule does not include. And we would change the word pro bono and to pro bono or indigent. they'd like to keep it in subcommittee and review a revised rule, or a new rule, it's not even revised, I haven't drafted it yet, in subcommittee before they present anything to the full committee.
Thank you, Nicole. The chair of that committee is sitting to my left. Judge Hairston Mitchell, do you want to fill us in on additional information from your subcommittee?
So Nicole was really thorough in what we have done in our subcommittee. So I first want to just start off by thanking all the members of the subcommittee for you new counselors that are here. That is where the work really does happen. And it actually is fun. So, and it's a great opportunity to really get to know your fellow bar counselors and kind of go back and forth about things. So I just want to thank the subcommittee members right now up front. I always like to do that. But as Nicole said, we all did meet and we agreed that this is a good rule, that we should continue to work on it. And as she stated, we have asked her to give us a rule, provide us with a rule that includes all these things that she just talked about. We had a lot of discussion about the language. It was really a whole lot about what wording should be in the rule, what those different words mean, who this rule should apply to. As she said, we talked about court-appointed attorneys and all those different lawyers, and whether or not we should include the other lawyers. And as she stated also, we thought that as of right now, we should just talk about having the rule, the lawyers that are included in here already as far as the nonprofit legal services, public interest organization lawyers, and other lawyers that represent indigent pro bono, but also to expand that to indigent or pro bono, because anybody that has done that type of work or is doing that type of work, there can be a difference. There definitely can be a difference. We also talked about the language of active and anticipated litigation, gifts versus loans, and what is a necessity, and whether or not there should be a cap on the amount of money or gifts that a lawyer does provide to a client, and what does the word modest mean? I know we as lawyers, we think when we see a word, we automatically, a lot of the words we think just mean what it says, but a lot of times when you start digging deep in these things, it's not always that straightforward. So we do have a lot of questions about those things. It was very robust discussion. I think that we do need to, we all agree that we do need to continue to have that discussion and have this rule, have Nicole draft that rule for us, and we would like to continue to do that work in our subcommittee. So that is my motion. I move that we allow us to continue to look at this in subcommittee.
Do Jack or Warren, you both were on the subcommittee, anything to add to the?
I have nothing really to add. As Dorothy said, it's an excellent conversation, but there is, and we've made a lot of progress, but there's still a long way to go.
So Warren?
Only that I think we're on the idea of expanding it to the other lawyers. We want to make sure that arguments about that don't impede the things that we agree on right now. And we might do that in a two-step process so that we can get folks that need that help right now, that we all agree on that help right now.
Thank you all. We have on the floor a motion to have this rule amendment remain in subcommittee. Do I have a second?
Second.
Any further discussion? All in favor say aye.
Aye.
All who oppose? The motion passes. Right, so now we're going to work on some pending inquiries, and we're going to start with proposed 2020 FEO 6, commenting publicly on client information contained in public records. And Suzanne is going to start us off on this topic.
Well, this is really in follow-up to the presentation that Brian gave about the rule amendments to Rule 1.6 and 1.9. But how this all started was in 2020, we got an inquiry from a lawyer who had participated in a very high-profile criminal case. And after the conclusion of the case, he received invitations to participate in CLEs and podcasts and various other public venues. He was prepared to limit his disclosures in the podcast, et cetera, to information that was in the public record or that had come out during the hearing. He didn't feel like he needed to have consent from his client because he was going to limit what he disclosed, but he went ahead and asked his client if it was okay for him to discuss the matter, and the client said, no, it's not okay. I don't want you to discuss my matter in any of these public arenas. And so the lawyer sent an inquiry to us asking whether he could basically ignore that request and speak about this matter with the public. A proposed opinion was drafted in October 2020. That was 2020 FEO 6. And I think a lot of you remember the reaction that we got to that proposed opinion. The proposed opinion said that the lawyer was not permitted to participate in the podcasts or CLEs, that any information the lawyer obtained during the representation, related to the representation, was confidential and he needed his client's consent, and that there was no exception in the rules of confidentiality for information that is in the public record. After we received so many responses, the matter was sent back to subcommittee. The subcommittee met many times, had lots of discussions. We had some group meetings. It was amazing discussion, really. And decided to table the opinion and instead focus on amendments to Rule 1.6 and 1.9 to be more practical, really, in the way that lawyers do CLEs and public education and those types of things. So the subcommittee came up with some amendments. They were submitted, approved, and as Brian said, they just recently got approved by the Supreme Court. So this whole time, the opinion has been tabled, waiting for the results from the Supreme Court. So we have those results now. We need to decide what we want to do with proposed 2020 FEO 6. So the original proposed opinion would no longer be correct because of the rule change. So the options we have now are we can withdraw that opinion as moot and not draft another opinion, or we can draft a new opinion applying the new rules as approved by the Supreme Court.
Thank you, Suzanne. Evan, you were the chair of that subcommittee.
Yeah, this is in its fourth year, and it really did generate quite a firestorm of comments from lawyers around the state, especially having to do with CLE and common practice. And I think the only two members, Todd was on that committee, and Ellen, is Ellen here today? I know Ellen Murphy, law professor, is on an advisory member, but she was on that committee. I don't see her here today, but so it's just Todd and me that are left standing. There's no question that at the time we decided 1.6 and that it was correct, and it was consistent with the ABA rules. It was consistent with 40 other states' interpretation of 1.6. In fact, Bill Powers was the one that generated this because he asked Bobby Kahn to be on his podcast, and Bobby had enough sense to ask his client to generate this, this question. So, and Suzanne is correct, given the changes in Rule 1.9, and our subcommittee really did work around the problems that were presented with the blanket prohibition of 1.6, where a lawyer cannot disclose or reveal information from any source whatsoever, whether it's in open court, and it is a blanket prohibition. But given the fact that Mr. Kahn's client is now a former client, this opinion really becomes moot. So I think what the correct way to go forward is to make a motion to withdraw this opinion, even though it was correct at the time we prepared it. The other option that Suzanne mentioned is to tweak this opinion and and make it right. And I know Todd and I have really been on the same page on this, despite the firestorm we got back from lawyers about their feeling they could no longer present at CLEs, they could no longer talk to mentors, they could no longer talk at bars about their clients, they could no longer post on their brag boards about, cases. And so so really it's either we withdraw it or we send it back to the subcommittee and drag it on for the 5th year to tweak it so it's correct. But I think after talking to Brian, probably the best way to go is to withdraw the opinion. But I really would like to hear from Todd. Todd has this ability to kind of sit back and take everything in and then come in with an incisive suggestion at just the right time.
I don't have much to add. I think Suzanne and Evan have accurately described what we did and how we did it and how difficult it was. It was an excellent opinion in my view. And I agree that it has now been rendered moot. So that being the case, I have no objection whatsoever. Would be very supportive of the notion of withdrawing it as moot and not continuing to revisit this.
So is that a second?
I'm happy to second it and move if you didn't make that motion. Yes.
Yes.
So is that published in the journal that we are withdrawing it and the reason that we're withdrawing it?
Yes, we'll make that a part of our ethics article in the journal to make sure that everyone's aware of that.
All right, so on the floor is a motion to withdraw the opinion that has been first and seconded. Any further discussion? Hearing none, all in favor, say aye.
Aye.
All who oppose? Motion passes.
That went on as long as now.
It is.
All right, our next topic is proposed 2022 FEO4 billing consideration for overlapping legal services. We're going to let Brian talk about this topic.
Right, so this opinion was published last year. The opinion addresses the situation where a lawyer is effectively doing work in this for multiple clients at the same time. The original opinion that was published addressed two situations. One, where a lawyer is traveling on an airplane and charging a travel fee while sitting on that airplane, an hourly fee, and at the same time on that airplane has pulled out his or her laptop and is doing work for a separate client and charging a full hourly rate. The question being, can a lawyer do that? Historically, we have told folks, no, you can't do that. That's something where you would need to prorate your services or choose to bill one client and not the other or what have you, but you can't charge a full hourly rate to one client while simultaneously charging a full hourly rate to another client. But essentially the efficiency you have created needs to be passed on to the client. The second inquiry addressed a slightly modified version of that, but came out with the same sort of analysis. The inquiry being if a lawyer goes to court just attend calendar call for 4 different clients and spends an hour attending calendar call for those 4 clients, can you charge all 4 clients a single hour? Which of course, again, the answer in the opinion was no. The subcommittee has met a couple of times, and after the first meeting, well, I should say we published the opinion and we did receive some comment back from folks that understood the basic concept, but we've also received, I guess, really kind of formal comment, written comment, but also a lot of verbal feedback from a number of different lawyers that express concerns with this notion that why can't I charge a travel fee while simultaneously charging an actual work fee, because neither client is really harmed by this. It's I can fully practice while I'm traveling. I'm doing the work for both clients. So why can I not issue those charges? And so based upon this different feedback, I know the full committee discussed this, I believe, at the July meeting. And the subcommittee took a look at this as well as other aspects. There were questions about unit billing, unit billing practice. I only charge in 6-minute increments or 15-minute increments, what have you. And how does this apply to flat fees? So the subcommittee has been working on revisions to the opinion. It's not complete yet. Currently, the opinion does stick with the original analysis for that scenario where the lawyer is appearing on behalf of 4 different clients at calendar call. I think that one is probably the most obvious. Just no, you can't charge 4 hours of work for that 1 hour in calendar call. That's not appropriate. I think the subcommittee is clear that the opinion does not apply to flat fee billing. If you charge a flat fee for that court appearance, then that's a different matter. And that this analysis does not prohibit unit billing, that you can engage in work. You can respond to an email that takes you 3 minutes and you're allowed to charge that 1 unit of 6 minutes, and then respond immediately thereafter to a different client and charge, or you spend 3 minutes on that email and charge another unit. Like that's a separate thing. The unit billing practice is not clearly excessive in that regard. You're also doing distinctly different work for different clients. The thing that the subcommittee is stuck on is the notion of travel. What do you do when you're traveling? And it's kind of, I feel like frankly, I think Davis can probably get into this a fair amount as well, as the chair of our subcommittee, that the subcommittee is kind of looking at this from all different angles. You kind of have on the one hand the notion that technology and practice today is in a place where lawyers can and are really expected to take on work, to do work whenever they're available to do so. When you're driving from Charlotte to Wilmington to attend a deposition, you get a call from a client, you may very well be expected to take that call because you just have to answer. And it's very convenient. A client is expecting you to be available, and frankly, you don't want to just ignore a client because that client may need your legal services. Saying that type of thing needs to be prohibited or needs to be, kind of go through this relatively complex thought of, well, exactly what time did I pick up the call? Now I need to discount that rate, but also discount my travel rate. That might create a disincentive for lawyers to actually respond to a client who's in need of legal services. And that's not what we want to do. So, there's this question of, well, maybe there should be some sort of recognition that a lawyer can complete those 2 tasks. I can travel for the client, and the client is not harmed when I'm traveling for. That client is not harmed by me doing legal work. And I should be able to I guess charge both clients the full amount respectively. But then on the other hand, there's we were discussing the notion of travel fees and convenience fees. The notion of a travel fee was based upon the idea that when you're traveling, say when all these other opinions, there's reference to other opinions in the original opinion, namely from the ABA and other jurisdictions that say, no, you can't do this, but those were issued in the 90s. You didn't have these types of things that we could bring on a computer or on an airplane to actually essentially have our whole office in front of us while we're sitting on that plane. So the travel fee was really a kind of a compensation for being taken off the market to do work. Now that you're not off the market, is a travel fee clearly excessive in and of itself? If you're able to do work, should you not charge a travel fee at all? So the bottom line is we're going in circles. We're talking in a lot of different, talking about this in a lot of different ways. I think it's a really good discussion, and we're at the point now where the subcommittee really wants to see a couple of different alternative analyses for this. So that's going to be my task over the next quarter to draft up a couple of different things, look at it on paper, see how the analysis comes out. But we're in a position now not to have anything for the full committee to act on. But it's kind of like we've sorted out some of it, but the one big piece remaining that we're probably getting the most feedback on, the travel aspect, is still something that we're trying to figure out. So, Davis, I don't know if I covered it all there.
I think you said it really well, and when it was originally published, the subcommittee wasn't formed yet. And so we talked about it in July based on the feedback. Then we formed a subcommittee and met in September. And worked really hard in that subcommittee. Then in October, we talked about it a little bit in the committee, and there was a lot of feedback that we received. Really, people had concerns, making sure we didn't want to over-regulate or step our boundaries in what we're trying to cover by this opinion. And so that's why we went back with the inquiry about, appearing in court. That's clearly dishonest if you're going to bill 4 hours for 1 hour of work. And that's why we went back and added some clarifications in there that this doesn't apply to a flat fee. We added another inquiry that we discussed at the last meeting last week that was about the unit billing. And in the unit billing, you're looking at people that send an email for 3 minutes and another email for 3 minutes, but they bill in 6-minute increments. And I think everybody's in agreement that it's a two-step process in looking at that. First, you have to have a clear fee agreement that specifies what your billing structure is, that your clients agree with it, that it's signed. And then the second inquiry is, is that clearly excessive or dishonest? And we agree that if you're sending an email for 3 minutes and you tell your client you're going to bill them for 6 minutes, then that's okay to do. But then that brings us to the last inquiry, which is really where we're kind of going back and forth on, and that's the travel inquiry. And as Brian said, we've got technology, we've got cloud-based servers, we've got remote PCs, we've got cell phones and computers and everything. We can work wherever we are. We can do work while we're traveling, and we're expected to some degree. We don't penalize them for that. There was some suggestions that maybe, we look at that two-step process. What if we put in our fee agreement that we're going to bill you a half rate for travel, and that you're okay with us doing other work while we're traveling, and that's in your fee agreement. You've agreed to that. So then, that brings up the second step. Well, is that excessive? Is that dishonest? Not dishonest, but is it excessive, and is it passing the efficiency over your client? And so we agreed. I think inside the subcommittee, I think we worked pretty hard to come to this agreement that we do need to address this issue. I don't think we need to let it go. But we thought that maybe the committee might want to discuss it a little bit. There's been another proposed opinion that Brian drafted internally that we discussed, but it's not for the committee yet. But we're just kind of opening up to the other subcommittee members to talk about our meetings and see if anybody in the big committee had any feedback.
Thank you, Davis. I'm on that sub, and Davis has done a remarkable job of letting us sort of chase a bunch of different rabbits to make sure that we have the opinion fully vetted. We have other members here, Jack, Bill, Lamar, Judge Hairston Mitchell. I don't know if you all have any more comments before we sort of solicit the group.
I don't.
No, I don't either.
All right. Well, we'll open it up to the full committee. If anybody has any questions or comments on sort of where this sub is stuck with regards to, well, what you've already heard, but also sort of the current issue of travel and how do you do that if you're also taking phone calls or drafting pleadings, things like that. Yes, Heidi.
And I knew that I covered this, but is there a difference between a travel fee, like a flat travel fee versus, for example, charging by your hourly rate if you're traveling?
Yeah, that's something that I think we've discussed in the subcommittee, this notion of if you just charge a flat rate. I'm traveling and I'm just charging you the $200 fee. We're not talking about just the logistics, the actual airline ticket or anything like that, but just a flat rate that is, I think we would all see that as a solution. As it's the hourly billing that kind of mucks it up.
Well, the hourly billing of another client or
hourly billing of two clients at one time. That's
how's the travel fee? If you do it, let's say, all right, I'm flying to Seattle, it's $500, and you're basically reserving their time for the purpose of travel. How's that any different from sort of like a true retainer, where someone pays you $1,500 to? Why are you not coming?
Because you're right.
It's public.
Let the record reflect. And I'm sure you guys have covered that, but I'm trying to wrap my head around the distinction?
What?
I think one issue with the travel is every travel is different. How do you set a flat fee for traveling from Wilmington to Charlotte versus Wilmington to Fayetteville? It's an hourly, commitment. So I'm sure we're not trying to regulate flat fees in terms of travel, but generally it's based on their hours. That's kind of what people bill for. This is my travel hourly rate, maybe discounted rate. But that's generally what we see and what we've discussed is hourly rates for travel.
I think it brings up the question of almost the value or the principle of, you're right, it's kind of a true retainer to some extent, like at least for that time period. But, what's the client expectation? You are traveling, and what would a client's reaction be if they're like, well, I'm paying you to travel, but while I'm paying you to travel, you're also billing at $400 an hour to do stuff for someone. Why am I paying you for travel if you're just basically sitting in your office? Like it's the virtual, the equivalent of sitting in your office, because yes, you're traveling, but you're able to do work as effectively as you were sitting in your office, which.
I don't agree with that analogy though, because you're essentially, first of all, it's in your engagement letter, start there, so they agree to it, there's a contractual agreement.
Right.
Second, you're reserving their time, no different than a true retainer. And, to ask the question, what's the difference between Fayetteville and Charlotte or Wilmington and Charlotte? Well, what's the difference between a $1,500 true retainer and a $2,000 true retainer? I mean, it's all sort of discretionary and they arbitrary, but if they've agreed to it, then.
I think that's where the flat fee could be the solution.
And that's the issue, is that you can problem solve around this, but the issue is that some people aren't. Most of them say, I charge you a certain rate for travel per hour. So that is the issue we're dealing with, not necessarily how you can work around it, because then there are workarounds to clearly explain to the client how things are going to be billed. So we have a couple hands. I'm going to run through us all in order. I know Evan.
Yeah, this is interesting to me, but I do mostly flat fees, but I also, if I'm traveling, I'll do a per diem. And I don't know whether that per diem falls into a flat fee or something else. And whether or not if I do a per diem of $3,500 a day and I've got time to work on another case, I'm confused whether now I'm violating some kind of rule on a per diem versus a flat fee. So I'll ask you guys to there are 100 different ways lawyers now can bill. I mean, and some of them are just extremely complicated. But I'd ask you, I want you to look into the per diem versus flat.
Wade, I think you were next.
I was just going to say that, being from Burlington, I would like to be paid my hourly rate if somebody wants me to get on an airplane. Because I may be sick for 2 weeks after I get off the airplane. And if I have to stay on the airplane 4 or 5 hours, then I've got more of a chance of being sick. And if I have to drive to Raleigh, and all that traffic. I mean, you guys cover it in your hourly rate, but I don't. So I don't understand why I don't understand why the public, especially if it's in your agreement, why the public would be upset by it. Because there is a risk in travel. And if you don't want to pay your lawyer to travel, do it virtually. Let your lawyer participate by Zoom.
And I think that's one of the things that we're looking at, just the general notion that it's not to say that travel fees are irrelevant and impermissible. I think we still are in the realm of, yes, they are. We see that there's a difference in the value of it. It may not be the same perspective as the 90s when all these opinions came out, which say you cannot charge a client full amount for travel and full amount for work when you're doing work for 2 different people at the same time. That's the principle, I guess, or the value that was articulated in these other opinions. And just that we're in a different environment, different practice reality. how do we reconcile that? Is there a client harm? I know we've had this in grievance rarely. I had a case early on where somebody was charging people their full travel thing. Like person traveled to a city in North Carolina for 3 different clients, had depositions over the course of a couple days, and charged each client the full travel rate to that city. It was a 3-hour drive, so each client got charged 3 hours of travel. And at some point, I don't remember how we got figured out. I think it may have been the firm that said, you can't do this. And maybe the lawyer just insisted on it, but it got to us. And it was one of those things that, well, you charge essentially 9 hours of work for 3 hours of actual work. And that's not okay. And we saw that with one of the local lawyers that did that with the federal government as a client and was, prosecuted and convicted. So it's hitting on kind of a value proposition as well. And I think that's where we're trying to work out where we are, what the expectations are today with regards to practice, with regards to our clients, the public interest, but also not trying to create a disincentive for lawyers to take that call, to take that work, create efficient mechanisms to do the work that is being requested of them by their clients. So that's where I think we find ourselves in a struggle.
And I think the other thing is, originally it came in and it was not so nicely named overlapping legal services. It was double billing.
Yeah.
And I mean, I'll speak for myself. I was like, no, you can't. This is easy. Publish the opinion.
Right.
Well, it's not easy. And so that's why we've even changed the name, because it's really more descriptive. So that's just a little background for people. Marcy?
2 things. Number one, I think that you point out it is very important that whatever this committee decides on when it's published is clear. So I like the idea of having more scenarios where you answer the questions. I think that the model that we use with communication with judges' opinion, I think, would work in this scenario to help lawyers make sure that what they're doing is accurate. This is near and dear to my heart because, I mean, I travel a lot, but not usually by airplane. I'm usually in my car, which means I cannot sit there and type out a property settlement agreement on my laptop while I'm driving. But the people that hire me that are not in my county, they hire me and they know that they're going to be paying me for travel because they know I don't live in their county, but they want me because I don't live in their county. And I don't think that those people would have any problem if I am driving to court, which I do all the time, and I return a phone call or two for other clients, as long as, I take their call first if their case is on for trial. So, I do think that, there are a lot of lawyers like me that do travel from one county to another county. And, again, your client knows that they're hiring somebody out of their county. They choose to do that.
Right.
Knowing they're going to pay for your travel. They understand that. You have that conversation with them. It is in your agreement. And I just don't see, you want to encourage, if you're in a trial, I had a 6-8 week trial last year. If I didn't return phone calls for 6 to 8 weeks.
Right.
So when I returned those calls?
Yeah.
When I was driving to and from court.
Right.
Well, and that's what we've discovered is sort of the outdatedness in a way of what the rule was, and we're sort of refining it to what people do now.
Right, but also my agreement has a minimum fee or bill, or whatever you want to call it, for phone calls.
Yeah.
So it's.
Yeah, and I think that's what the opinion does not say that you can't do work in this simultaneous fashion. It's just a question of how are you supposed to bill? And if we issued an opinion that did say, lawyer, you can charge full hourly rate for travel or whatever the agreed upon rate for travel is, and full hourly rate to another client for the work that you're completing while you're traveling for another client, we would be the only jurisdiction in the United States that has that opinion. And I think that's perhaps, is that reason to give us pause? Or is that reason to say, like we were talking about, reality is just different. And what is the client harm that we're protecting against? And, all these different things. So that's, I guess I just want to kind of frame it in that regard and why perhaps we're trying to dig into the weeds a bit to make sure that it's right.
So Bert?
You say that we would be the only one to have an opinion like that.
Yeah.
I have a feeling that maybe the other 49 states don't want to look in that corner.
Right.
Yeah.
We have that discussion.
I agree.
It's been going on since, the Model T probably was reported.
Right.
I think that, what your committee is doing great. I do like the scenarios, but I do think that we just need to keep it, keep it simple, stupid.
Yeah.
If you can. But at the same time, clients, for the most part, have become more sophisticated over the years, especially when it comes to travel. If you're getting into travel type of scenarios, you're probably dealing with somewhat of a sophisticated client in the sense that they're going to be able to afford travel. I mean, it won't be like indigent clients. You know, the scenario about you said about 3 hours and 3 hours and 3 hours. That's the same scenario as sitting in court. I mean, I'm sitting in court for an hour, and I'm going to charge them 1 hour 4 times. Well, I mean, you can't charge the same person travel 3 times. But if you're traveling and you have a travel arrangement, and if it's clearly stated in the agreement, I think that is that's proper. You know, that's proper because that's between you and the client. And when it comes to, the word excessive, I mean, I guess there could be degrees of excessive, but I think when it becomes excessive at our level, when it clearly, or even a little bit, shocks the conscience. When you bill 20 hours in a 24-hour day, that's excessive. What that attorney you were saying that got prosecuted, he was coming in from a unit billing standpoint, and so he was probably about 20, 30 years ahead of his time, about that because dealing with that. But of course, that was with the federal government, and so and that's a little different. Right. So, but you're a sophisticated client, the federal government. So, I mean, if the government says that's fine, that's fine. My guess is the government probably didn't say that, but I'm just saying that if it's in the agreement and if they understand and they want that immediate access to Madam President over here because they got an issue, it's on their mind. My guess is family law is going to be emotional. They don't care what they're doing. If they can pick up the phone, I mean, they don't care if you're in a doctor's office. They want to talk to you. So I guess what I'm saying is I just don't think that as long as we're clear, it's not that we're saying it's okay, but as long as your client says it's okay, and you make that very clear ahead of time, I don't see any issue.
Gina, we got a
So
little list here.
These two stole my thunder a little bit, but I think when the subcommittee is evaluating how we're protecting the public, I think we have to think about what is it that the public wants. We have a tendency just to think about money, but I think these two are making the point that the 2023 public wants you to respond to their email that day. Right. They don't give a flip where you are or what you're doing, and are they willing to pay for that access, for that response time, for that efficiency? I believe that they are. So let's not presume to know that we're protecting them over here when what they really want is over here.
That's a good point. Todd.
It's been touched upon as I was thinking about it. This is fairly straightforward. Is North Carolina on the verge of being the first jurisdiction to discuss this issue since the 1990s, given all the technological advances that have occurred since then? Are we about to be the first
the most recent opinion was sometime mid-2000s, and it just basically reiterated what the ABA decided in 1990s.
Wow.
Heidi.
So the issue is whether it's clearly excessive, right? So when you sit there and think, if I drive to Moore County and I sit and I'm bebopping to my music, but I'm charging this person, I mean, that to me feels worse almost than if I'm utilizing it. I mean, they know I have to drive there. To Marcy's point, if they've hired me, they know I'm in Wake County, I have to drive to Carthage, and we have that agreement and understanding, and they're gonna pay me for it. If I spend the time talking on the phone with another client or lawyer or whatever in another case, I don't understand if you have an agreement and they're paying for my time, they know what they've signed up for, they're presumably relatively intelligent, sophisticated people, what the issue is so much.
And as I'm hearing this, there's something, maybe I'll put it this way as a question to everyone. It seems like everyone agrees that the notion of I'm charging 9 hours for 3 hours of actual work, you can't do that. That's dishonest. In the situation where you're traveling for 1 hour and you spend, let's say, 30 minutes of that time on the phone with another client, can you charge 90 minutes of work for that 1 hour of actual time that was spent? You charge 90 minutes, you've billed for 90 minutes of work over only 60 actual minutes. Is that the dishonest thing, or is it different? And that's this thing that I think we struggle with. Is it different?
I mean, if you do minimum fee billing or unit, it may take you less time to do a pleading than it's actually what you're charging for, because you're charging a minimum fee. It's in your contract.
Right,
So
right. Yes.
You're going to pay X dollars for a complaint.
Right.
All right. It may take you less that time to do that because
Right.
you've got technology. You pay for those computers. You pay to update that technology. You pay a lot to have great paralegals to help. So I mean,
Yeah.
Well, I think one of the things is that I had proposed the sub is why can't the answer just be have a clear fee contract?
Mm-hmm.
That would be great. I mean, that would be great if everyone just properly addressed it in their fee contract.
maybe that's what needs to be addressed in this opinion is,
Right.
you know, it's-
Absolutely.
Yeah, that's.
But the question is with the people who have contracts that they're not going to revise or set it out. In other words, what does it mean? So we've got a lot of
you
hands.
get called in for.
Warren, I've been keeping track.
So, under existing ethics rules right now, hypothetically, if I did, let's say, 32-minute emails in an hour, and I bill at a rate of 0.1 of an hour for a 6-minute increment, I just billed 2 hours, 1 hour, right?
Yeah.
And our clients have understood that forever, and we explained that in our fee agreement, and they agree to that, and maybe they get mad if they saw that I sent all these different bills and they added it up and they saw, oh my God, you got it. But they got what they paid for. And
Yeah.
that's where the point is the misleading of the client. They got what they paid for, they agreed to it on the front end. And it's really, we're kind of dodging around because somebody called this double billing one day back in the 90s or 80s, and we're all worried about that. The point is misleading or not misleading, being clear with the client. I guess I don't get the differentiation between travel time, unit billing, all that stuff. It's whether the client understands. And some clients, most clients that pay hourly, well, I don't want to say that. There are a lot of clients that pay hourly that aren't very sophisticated. But I'm just saying there's a lot of clients that do pay hourly that are very sophisticated and they don't want their lawyers. They want their lawyers to be on call at all times.
Davis.
So just Warren's point, we did add that second another inquiry that's not in the materials about the unit billing and how it's in the agreement. It's okay.
Oh, right. But I'm just saying, I don't see the intellectual difference.
With the travel issue, the thing we talked about how we would be the first jurisdiction is really what we would be stating in an opinion would be a differentiating, basically saying travel time is not legal service. It's, what we're looking is billing for legal services. Travel time is not a legal service, therefore there are two different types of services and they're not overlapping.
Right.
And it sounds like there's some support for that if it's clearly stated in the agreement, not dishonest.
Yeah, I think that's the distinction. What you were saying, Warren, the unit billing, it's like you're doing work for one client, and that's distinct and separate from the other work that you're doing for another client. And travel services occur at the exact same time as legal services for a different client. That's the overlap. But like Davis said, that's one of the things that we were discussing at the last meeting is maybe those are distinct, different tasks that can be completed at the same time to the benefit of both clients in a way that doesn't detrimentally affect it. So that's,
Tara.
Most people have said this already just in the last couple of minutes, but it seems like, again, everybody agrees on the basics, but how to communicate it is the issue. And I feel like public perception is the main problem here. Because just like you said, Catherine, if I hear double billing, I'm like, ooh, that's not good. But if you hear overlapping services, maybe that has a different spin. And whoever came up with that different term, I think, that's the vein, that's the direction we need to go into, like, communicating why it's different should be the priority, whether or not is this right or wrong. Because for a lot of people in here, it seems like there's a remarkable consensus, this is okay, this isn't. So I do think that communicating why it's different is where the focus needs to be.
Well, Davis, you've heard a lot of comments. Do you have a motion? Oh, wait a minute, I've got another, Todd.
I'm sitting there thinking,
He's thinking.
no, I get the billable rate issue. Did you guys address, for example, the fee component of this? Because if you charge for mileage, are you then, after this 4-hour trip, going to go back and allocate the mileage to all these folks you're going to send a bill to for that hour, for that 10 minutes of time? So
Yeah, we have not addressed that. We were only focused on the hourly billing aspect, because that's where I guess that's what was proposed, and also to me, kind of like the flat fee. Is that a workaround? I'm only charging mileage. I'm not charging my time. Is that the difference in a potential solution? But no, we have not addressed this.
Yeah.
All right, maybe I'm just beating the dead horse, but I do like what he says about the travel time is not legal service.
Yeah.
Per diem is not legal service. Buying that plane ticket is not legal service. In order for you to travel to where you're going, mileage isn't legal service. And I would say that you put in there, you can only bill one travel time to one client. And so there would be no, I'm going to charge 2 hours travel for 3 clients. I mean that shocks the conscience. I mean, that's clearly excessive. But I do like that differentiation. But whatever you decide, it's got to be clear, because then everyone's going to be confused. And folks are going to be confused anyway. And it's got to be and they've got to take responsibility that it's in their agreement. And if they're not going to do agreements, well then they're going to be called up to grievance. And it only takes 1 or 2, and then everyone's like, well, maybe I do need to get an agreement.
Well, the good news is, I don't know if we'll be alone. This subcommittee will be around for 4 years, but I think we're at the beginning of vetting an issue. And so, Davis, do you have a motion?
I was thinking in subcommittee.
And the only thing I'd add, and I think the discussion's great, and this is kind of how it's been going on the committee, but going to Marcy's point, and Bert's, it would be great, and also Todd's, it would be great to have the specificity. However, what we found is that each time, there are the couple that we could handle, that we understood, as Davis laid about. But every time we started the deep dive into the next one, like what you're talking about, Todd, well now, are we going to try and micromanage the way people do their mileage sheets? Oh, for the love of sweet Moses, I hope not. I mean, so it's like we have to be very careful to allow a certain amount of common sense for the lawyer to do. We're lawyers. We should be allowed a certain
The client that
amount.
should pay for the travel is the one who has to have you there. I mean, they're the ones who pay for your travel. The people that you're just calling on the way, or you're just trying to get back to them as quickly as possible, because otherwise you're going to be reported a grievance because you've been in a trial for 6 weeks, and now you're not returning calls on time, and your client's going to be mad at you. But the travel fee is for the client that needs you to travel.
Right, exactly. I totally agree. And my point is just on the specificity piece. I don't think we should anticipate that we're going to have an 1,800-page flow chart on what you have to do every minute of your time. That would be horrible.
And I think that's just, again, originally this came in as double billing. And I think everyone said, whoa, we can't double bill. But now we're refining it. I heard somebody say ancillary services. I mean, so we really just have to be clear, and, the devil's in the details. You're probably going to see multiple drafts. And I know on the floor is a motion to remain in subcommittee. Second. Any further discussion on that topic?
Captain should stay there.
All right. All in favor of this issue remaining in sub, say aye.
Aye.
Any who oppose? The motion passes.
Oh, Lord.
I guess we haven't done it for a while.
So it's 10:21, and I'm not. The next inquiry may take a little bit of time, so let's take about a 10-minute break and come back. 10:30, 8 minutes.
Show me how to do my bookmarks, baby. They just-
I still have. I was like, no, we can't go.
Don't mind me.
We weren't talking about how it was like 4
years.
Because it is.
So that's where. I mean, I should think that out.
To me, this is like, that's where the travel thing is.
Like I had trouble yesterday. Here, now that I'm on, it's all funky.
99 times out of 10. Doesn't mean that's okay, but some odds of them.
He thinks I'm such an idiot. And that's what I'm like, I swear to God.
They're being basically,
I have problems that now I can't.
Well, at least you had it the way you
Yeah,
wanted.
right, right. That's what
I was thinking too. I'm like, I just usually call somebody. Peter can fix it. Or your IT person.
Yeah, they think I'm an idiot too. I guess that everybody that has to.
I readily agree. I'm an idiot when it comes to technology. I'm the first one to admit that. We're gonna stick. I'm like, I cannot do it. I don't even try.
I'm always,
Let me know.
Where are we?
Yeah, I know.
This is gonna be, this is gonna be.
What's up, Ms. Fine?
Yeah, same old.
Yeah, I get that a lot, lawyers on my community. It's interesting because that was my
Yeah,
thought
two baseball
when I
kids,
applied
that's
for this job. My daughter was, I think you're old.
And I'm not imagine some prior opinion on it.
I'm trying to get.
It's like the travel jobs, like Debbie said, it's intimidating.
I'm curious about it.
That
helps.
And my husband is that.
And that was the big word. It's like, I like to hit parties, but I don't really care about paying
And so I
attention.
said, well, I can't do it. She's like, I've got to get at it.
It's all.
And I saw this job description, it's just like, this is like the best of two.
Gymnastics is
I still get to be a lawyer.
Well, now they're in different classes.
Oh, yeah. Oh, yeah.
So it's
So
like.
you're taking
I'm not being.
Yes, I'm taking
Yeah.
gymnastics.
He's at the beginning of
Yeah, yeah. I used to do.
Yes.
That was.
And I get lots of,
that
you
was,
probably never heard this before, it's like, you're right, I haven't heard this before, what is going on?
But yeah, like the student thing in college.
Yeah, I'm very happy.
Always doing something like. You think he Yes, yeah, no, I did not.
Okay.
But he would like, he's a course, he did gymnastics. Oh, yeah, you can have a great shoulders. That's difficult to answer those kind of questions. Yeah, exactly. I was like, no, I injured my shoulder, I couldn't even do it, you know, it's like such a stupidest thing. It never got anywhere. It was never successful. Like, conversation.
I had my first audit.
I think you would like it.
And that man came in with a half paper, and I was like, I kept doing that. But then it thought he was the nicest guy. That's great. And so
I think that's what really like that was going to work. That's like, that's
Sure, Barbara.
I'm glad.
I can't wait to read the next one.
Yes, yeah, right.
Now I want to find a reason.
And I was always that way. I'm like,
Which one was it? No, weird.
Oh, I
I was like, I'm gonna leave it in, figure it out, the best thing is.
it was really just a record keeping, which, you know, now the reconciliations,
It's so much.
I've gotten in a good routine and we just reconcile because it's so much easier than doing it for anything. And we just have a good routine and I'm a great person.
But you have somebody like goes back up and.
We'll see what happens. Somebody might see it.
No, I mean, I know. I mean, I do, but like not as like no one else can sign trust me.
Right.
But I've got a bookkeeper former CPA who's got my CPA, and I've got like instructions for lawyers who help me. But
That's what I think it's just best to help out. If we get another grievance, I mean, I shouldn't take her away to.
Figure out how to.
You guys did your job.
Great art.
and she's still, I think she did a job now for it has deadlines and everything. And then we updated.
The one where I told you.
Yeah, just in case something. They can walk along and say, hey, Catherine has a notebook. Here it is. Yeah.
Well, Sydney's not here. Oh, good. That stream is still on.
Oh, wow.
You have
Cool.
Yes, it should be.
Next one.
Increases my,
My butt's
Oh, that's
That was a good point. First recommendation to some of these issues, not they were.
They already are.
Yeah. They're not this.
We had a serious discussion about this.
Exactly.
But then, Bill Powers made a good point. I don't know that we should run away from something that's gonna be complex. We need to know it from the beginning, like when there's a here, and then do this repeatedly, right? And so.
It's a naughty issue. And then it'll go out to the person. All right, well, it is what it is. It wasn't nice when it got to tackle the deal. That's right.
All right, everybody, let's get back to business. I think we've got about everybody back. So our next inquiry is about the sale of a law practice and the proper handling of aged client files. And I'm going to have Brian, you start with an overview, and then we'll have Judge Bell give more information from the subcommittee.
Right, so this was the inquiry from staff. The origin of this one, for those that are new on the committee, was just a couple of different inquiries that staff has received about what do I need to do, a lawyer that's trying to sell my practice, close my practice. Oh, by the way, I have 30 years of old client files, and I'm not sure exactly what I should do. Yes, some of them have original wills, but can I just get rid of those things? So, it became kind of clear from our discussions that there really was an opportunity to offer some guidance, some assistance to lawyers, and really a resource, and that's where the opinion comes from. You have in your materials an opinion that the subcommittee had discussed, revised a number of times. This was introduced originally, I believe, in April of last year. And the subcommittee has met a great number of times. I think we've met twice per quarter over the past 2 quarters, and came out with this particular opinion. You see here, I'm not going to go through the entire opinion because the opinion has 11 different inquiries. But it does because this is one of those, again, where it's like we're going to start with one spot. We think it's pretty straightforward, but we realize we need to address these different aspects of it. But again, the scenario is lawyers selling a practice to another lawyer, and really trying to walk through the requirements of Rule 1.17, which is the rule applicable to selling a law practice, to make sure that lawyers can understand in this scenario just what does somebody have to do when they're selling the practice. First, identify a lawyer that is competent to take over these cases, if that's the intent. It's one of those things I think is kind of an obvious thing, but sometimes it's kind of lost that it's not just okay to say, well, I'm selling my practice and Joe Smith, I don't know what Joe Smith does, but okay, you can take all of my active criminal client files. If Joe doesn't have a criminal practice, that might not be the competent person to take it over, and you, current lawyer for these clients, have a duty to identify somebody that can continue the services. But then goes through the process, the questions of notice. When you have to send out a notice to clients, who do you need to send that notice to? The opinion clarifies something that I think we've heard from other lawyers in these different inquiries that there was some confusion on, that notice must be sent. If you're basically selling your practice and transferring those files to somebody, notice needs to be sent to all affected clients. That means that current clients who have active cases, of course, they need to be notified that their matter is being transferred to another lawyer. But former clients whose information is being transferred to another lawyer, they also need to be notified. And so it goes through that type of notice. Now, what actually constitutes notice? The opinion goes into the notion that this is not actual notice. There's no requirement to serve people under Rule 4 or anything like that. But that notice really needs to be reasonable under the circumstances. A lawyer needs to make reasonable efforts to get that notice to somebody, understanding that there are some clients that may be unreachable. So the opinion goes in and provides some examples of, if you have a client's last known email address and you send that and it doesn't get bounced back, under the circumstances based upon your prior communication with the client, if you feel that that notice likely reached their inbox and they still didn't object or come get their client file, then that should be reasonable. Using their last known mailing address, sending a letter there, that's an option as well. But again, the opinion goes into some detail on exactly what type of notice would be reasonable under the circumstances. The opinion goes on to talk about aged client files, an original client property. What is a lawyer to do when you're talking about not just old file materials, but you're talking about what we'll call client property, which is what a will is, an active original will or power of attorney that the client has asked you, lawyer, to keep on file, to essentially act as a repository for the client. The opinion does stress that this practice of keeping original wills with lawyers really should be reevaluated. That original documents that are the client's property should be given back to the client. Because it's the client property. We have a duty under Rule 1.16 upon termination of the representation to return client property. But just the reality, and we've run into this not just in the ethics department, but I know in my time in the Office of Counsel, when I helped out with some of the trustee issues, that lawyers, or maybe I should say clients, ask their lawyers to hold on to the will for an indefinite period of time, expecting that the lawyer is just always going to be there. But that's not the case. And so we would get calls to the bar, I'm looking for my mother's will, and I know that so-and-so lawyer drafted it back in 2002. I don't know where that lawyer is. Well, our records show that lawyer actually passed away in 2008, and now I'm not really sure where that will is. So it's, those things, just kind of the opinion, again, tries to stress lawyers should give back that type of client property upon the conclusion of the representation when the client is right in front of you, clearly available, and not necessarily act as a repository. But if a lawyer does keep that type of property in their possession, that a lawyer does have a duty to safeguard that property and to make sure that clients know where that property is. If you sell your practice and you transfer it to the purchasing lawyer, that notice needs to be sent to the individual, and maybe there may be some additional efforts, again, depending upon the circumstances, that need to be taken to make sure client is aware of the location of this very important document. So the opinion, again, goes through those different scenarios and tries to distinguish just what a lawyer's responsibility is under these various circumstances that are associated with closing down a practice or selling a practice. Again, it's a long opinion. It's in your materials, but ultimately the subcommittee arrived at this draft that's in the agenda for your consideration, and I'll let Judge Bell address any motions or other considerations.
I think you did an outstanding job.
Thank you.
I think the only issue in my mind that was kind of seemed like it depended on where your practice was. Some committee members talked about they don't ever keep, for example, I said when I was in private practice, I didn't ever keep an original document. I gave it back to clients. But some people talked about in their practice, clients want them to keep those original documents. So it certainly seems like it's easier not to keep the original document, then you don't have to worry about it, you just got a copy. But and I actually had this situation come up after I went on the bench. Somebody who had died, their relatives called me and said, do you have the will? And I said, not the original. And so that was the end of that.
Yeah.
So that's really all I can Ed.
Yeah.
Thank you. Anybody else on that subcommittee? Lauren, Stacy?
I'd like to say, it's my first subcommittee, and I didn't realize the detailed discussions to go into, but we really did vet every single one of these. And as someone who may retire in the next 10 years, you know, it's near and dear to my heart, this issue. And I think there was a lot of thought, and I really appreciate Brian's attention to detail in redrafting. So.
I have nothing to add other than a move to do what we're supposed to do next, right?
Could you make that motion a little more specific?
A motion to do what we're supposed to do.
To publish?
Motion to publish, yes.
Second.
So we have a first and a second on a motion to publish the lengthy opinion that you all have worked so hard on. Any further comments, questions? Yes, Lauren.
Yeah, I just, not directly with the opinion itself, but reading through it to sort of piggyback on Judge Bell, her comments is, when I read through the opinion, I'm thinking to myself, okay, this is a list of like 15 reasons why I'm giving the originals back to my client when I'm done representing them. I know I practice transactional law, so there's reasons why you can't sometimes, but I wonder, my point is, I wonder if at some point might be a good idea to, once this opinion hopefully does in the past, to do an article on best practices or people who were in that sort of situation a lot, suggestions, give it back, but if you can't, here's some best practices on how to keep it, what to do that's consistent with this opinion.
Right.
And that might also be the bar a tool to provide people when they're struggling with something.
So we have an old article that about closing the practice, but it's old.
Or maybe just revisit that article.
Exactly.
After this opinion is.
Yeah, it's a great idea.
Did Lamar just volunteer to?
No.
Yeah.
Evan.
Yeah, well, one of the issues that has come up on the Issues Committee that's going to be looked at is succession planning. And so that's in its infancy right now, but I think that kind of dovetails with this somewhat, and hopefully we can get that going pretty quickly, because that's an important issue.
Yeah.
So right now we have on the floor a motion to publish this opinion that has been seconded. Any further comments? All right. All in favor, say aye.
Aye.
Any who oppose? Motion passes. Okay, next topic is going to be the inquiry of the North Carolina Dispute Resolution Commission about lawyer mediator drafting terms of mediation for pro se parties. And Suzanne is going to start us off with a summary.
We received an inquiry from the North Carolina Dispute Resolution Commission, and staff went ahead and drafted a proposed opinion that was presented at last quarter's meeting, and you guys decided that it needed to go back to, well, I think you recommended it needed to go to subcommittees for some further study, so it went back. We had a subcommittee meeting, and we were fortunate to have Sarah Cromer, who was the lawyer who submitted the inquiry, and Tara Kozlowski, who is the executive director of the North Carolina Dispute Resolution Commission. They attended the meeting with us. The inquiry deals with mediations between two pro se parties. Sarah Cromer, who is a certified mediator, told the subcommittee that sometimes she's faced with the issue of beginning to mediate between two pro se parties, and there needs to be some terms of the mediation process established prior to starting. If there's lawyers involved, the lawyers will usually get together and draft the terms of the mediation process, but when it's pro se parties, nobody has done it, and the issue is whether it's permissible for the lawyer mediator to draft this agreement between the two pro se parties, setting out the parameters for the mediation, such as whether everything's going to be confidential, whether they can call each other as witnesses, whether anything can be recorded, things like that. Sarah said that the lawyer mediators right now are cautious about drafting any type of agreement because there is an ethics opinion, 2012 FEO2, which is another, which talks about a mediation, and it says that a lawyer mediator cannot draft a contract for two pro se parties at the conclusion of a successful mediation. So that kind of talks about what the mediator can't do at the end of the mediation, and this is sort of looking at what can the mediator do at the beginning. The proposed opinion that we drafted concluded that it was okay for the lawyer mediator to draft the agreement between the two parties because it was just such a limited representation under Rule 1.2, and because it seemed like the conflict of interest was something that could be waived because the agreement was really for the mediation process itself, not so much for the two parties, and anything in the agreement would apply to both parties equally. Tara, again, she's the executive director of the DRC, pointed out to us that they have conflict rules, and she noted that their conflict rules are stricter than ours, and she said under their rules, if a lawyer does any type of representation of the parties at the beginning of the mediation, even if it's just setting out the terms of the mediation, that the lawyer cannot then switch hats in the mediation. So she sort of said that the proposed opinion as drafted would go against what their conflict of interest rules are. So we talked about that as a subcommittee, that any further opinion would have to take their rules into account. But then Gina, who was the chair of the committee, piped up and said that she had actually gotten in contact with Paul LaChance, who is the forms manager, I think, at AOC, and she told Mr. LaChance what was going on. She said, we're looking at an inquiry, we're trying to figure out what the best way to handle this is, and Gina thought it would be a good idea to have a AOC form that lawyers could use. And so she asked him how would we go about doing that, and he said, well, I'll be happy to look at it as long as the DRC is also on board. So Gina's presenting this to the subcommittee. Meanwhile, Tara from DRC is texting or emailing Paul LaChance saying we are on board. So hopefully there's going to be a AOC mediation agreement form that's in the works. So the subcommittee decided at that point that they should table the opinion to see what type of form comes out, and then they can tailor the opinion around the AOC form. And so that's where we are now. And Gina kind of came in and saved the day on that one.
Well, but here's why. I'm a cheater. And this is a simple issue, and it takes 3 pages to answer it. And so I was like, there's got to be a cheater way around this. And I am a family lawyer, and we use this MOJ form in court all of the time. It is an AOC form that has some boilerplate language and then a big old paragraph where you're at the courthouse and you handwrite the 3 or 4 things that substantive that don't that are not in the boilerplate thing. The judge signs it. Boom! You've got a court order. It's enforceable. We generally do another court order. The AOC MOJ form says you don't have to do another order, but generally there's some details that we want to put in it, so we do. But if we never agree to that one, the one we've already done in the courthouse is enforceable. And that thing's been a game changer for all district court practitioners. And so I'm like, well, that's on the back end. Why can't we on the front end have a mediation services order that says the mediator is going to mediate this case and the parties agree to 3 things: that the process is confidential, that nobody's going to record it, and what's the third?
You're not going to call him as a witness.
Yes, the mediator can't be called as a witness, and that's really all that the DRC wants. And I'm like, oh, come on, surely that can be a little contract. And Clarence Horton, whoever remembers him, he had you do that. When you used him as a mediator after he came off the Court of Appeals, he had a little agreement that had like 3 or 4 things on it, and everybody had to sign it before you mediated it. So I'm hoping, since our subcommittee, I also happen to be on the phone with Deb Dillman, who's on the NCBA DRC committee, and she says they'd be all over it too. So I'm like, come on, if we've got the DRC, the State Bar, and the NCBA, surely we can talk AOC into doing it.
Not cheating, exceptionally efficient.
Yes, such a practical
And
solution.
Before I get to you, Lori, I'm just gonna see if anybody else on the subcommittee, Judge Bell, Lamar, Elizabeth, if you have anything to add to what's been said so far, and then we go to Lori.
Yeah, just briefly, even with an AOC forum, we still have to ultimately cross the threshold of saying that a mediator takes this forum and asks the parties to sign it, isn't providing legal services to either party because then you have a conflict situation.
Right.
I think it's an easier answer because you got a simple forum, whatever, but you still have to ultimately do that analysis. But it makes it an easier analysis.
Lori?
I think that would be a good idea.
Then number 4, our representative.
Not your attorney.
In family court, all of our custody cases are required to attend courthouse mediation. And the courthouse mediation has rules that they send to people before they participate in the mediation. One of the rules, and I had a client send it to me, you're not allowed to record the mediation session, and the information discussed in mediation is confidential and privileged and cannot be used in court. And if you're not willing to abide by those rules, you can't participate in the mediation. I don't see why clients can't sign off on that if they're pro bono before participating in mediation. But what I find even more interesting is the mediator in these court required mediations then goes on to draft a parenting agreement and does draft the terms of the parties. And it's turned into a court order. So they take it to their lawyers, and we have an opportunity to comment on it and request changes. We have that discussion with our clients. But pro se people mediate in this all the time and don't have lawyers to take it. They just go in and sign off, and it becomes a court order.
So how's that different than what we're talking about?
Yeah. Well, it is done by a non-lawyer mediator, but they're a courthouse mediator.
I think
I guess they're not governed by our NC bar.
But they don't have the DR, and I mean, that's almost more the practice of law by a non-lawyer, if that's part of what you're saying.
I think that's where our prior opinion talks about that being more of a recordation of the agreement as opposed to drafting something for the parties to sign, even though I know it's.
Some of these are terms of art, but.
Yes.
Legal custody, what actually does that mean? I'm not sure.
Wade?
I don't know if they talk about legal custody, I think they talk about parenting now.
They do.
Wade?
I was just looking at it from a different perspective. I think mediators are allowed to have agreements with each of their clients, right? So my mediation client signs an agreement with me, and then the other mediation client signs an agreement with me. I can put anything I want to in that agreement, including confidentiality, not recording it, whatever. And they're not agreeing with each other. They're agreeing with me. But each of them is a third-party beneficiary of the other's agreement with me. So it seems to me that this is something that whether AOC gets on board or not, if you're a mediator, you should be able to do this without running afoul of the DRC.
Yeah, and that part, the inquiry that came in was that last part that you mentioned of it's not the parties that are essentially signing something to be enforced against each other. That was the inquiry. Can a mediator draft terms for the parties to sign where the mediator is not a party to that agreement? I'm just drafting something because I guess the request was that one party wants this term of confidentiality and be able to enforce that against the other party participating in mediation if they breach confidentiality. So suddenly mediator is drafting essentially a contract.
Well, but why would you even need to do that? That's my question.
I guess
they both agree with you.
Yeah.
And they both got copies of the contract they signed with you, then why aren't they both bound by the same contract and both beneficiaries.
I think y'all, you live in a different universe than the universe that this inquiry is coming out of. I think in this universe, it is a mediator who is mediating a church.
There's church organizations.
Church
and-
squabble. And so having a sophisticated legal services contract when you're a mediator is not what's going to happen in this case. These people might be in folding chairs in, a fellowship hall kind of a thing. So we're trying to do something that solves that problem. You guys are raising, of course, they're both new on the committee. Look at the spoilers. Coming in here saying, how about this? But I think those are very valid points. They're just not necessarily the lane that we were in with this inquiry.
Thank you.
So with that, do we have any motions? Maybe for it to remain in subcommittee?
I would move that it remain in subcommittee so we can hear what DRC has to say about it.
Second? Any further discussion? All in favor of having this inquiry remain in subcommittee, say aye.
Aye.
All who oppose? Motion passes. All right, next we have inquiry of Mullins, imposition of confidentiality in settlement documents, and Nicole is going to present on this.
This is an inquiry we received from a plaintiff's lawyer who was involved in litigation, protracted litigation with defendants. They had a trial, they went up to the Court of Appeals, and ultimately for the financial side of it, for the damages side, they settled the matter. Defense counsel prepared a settlement agreement that included a very broad confidentiality clause that not only applied to the parties, but also to plaintiff's counsel. Plaintiff's counsel objected, stating that the confidentiality clause, which included, it basically stated, lawyer, you can't talk about this case ever to anybody. You can't use any of the information for representation of future clients. And plaintiff's counsel was upset that it violated Rule 5.6 restriction on limiting a lawyer's ability to practice law, because she wanted to be able to use the publicly available information, such as that Court of Appeals decision, that actually created new law in this, it was a MedMal case, but it created new law in North Carolina. So she wanted to be able to talk about that at CLEs, to put it on listservs, and to also use it to benefit future clients. And defense counsel had drafted a confidentiality clause that would put a limit or a gag on that. So she wrote in asking, first she asked for informal advice, and of course I can't advise her on what defense counsel did, so I told her, have defense counsel call me. I tried to work it out between the two of them, but we're here with a proposed opinion. The opinion relies on Rule 5.6 restriction that lawyers can't sign any kind of agreement that would restrict their ability to practice law. There are two ABA opinions. If you look in the opinion, there's an Alabama opinion, and also a couple of North Carolina opinions that basically state that a restriction on a lawyer's right to practice undermines the purpose of Rule 5.6, which is to preserve access for the public to find lawyers who are best suited to handle their matter based on their experience and their background. So we want those lawyers to be available to the public. It's also to prevent parties from buying off the opposing counsel, and to prevent conflicts of interest that the lawyer has between present clients and future clients with regard to being able to use information in one client's matter for a future client's matter. So the opinion basically provides that lawyers cannot agree to any confidentiality clause that would prohibit the lawyer from discussing or disclosing or using publicly available information. Now, the opinion does recognize that there are some confidentiality restrictions that should be allowed, such as the settlement terms. The amount that the settlement can be confidential, but anything that is already in the public record or publicly available, the lawyer should be able to use that. So opinion number 3 addresses that and says that the lawyer can speak about the case in CLEs, listservs, emails, conversations with other lawyers, any other public forum that they can talk about things that are in the public, on the public record. Opinion number 4 cites other rules of professional conduct that are impacted by a lawyer having to sign a confidentiality agreement, and those include Rule 3.3 on candor towards the tribunal, Rule 3.4 fairness to opposing counsel and party, and Rule 8.4D on misconduct that is prejudicial to the administration of justice. So the subcommittee met, they really liked the opinion and thought that the opinion was correct as written, except that they did direct me to include a comment or a discussion about Rule 1.7 and a lawyer having a personal conflict of interest in not signing an agreement that includes this confidentiality clause put against a client's interest in signing the agreement and getting the settlement resolved and taken care of. So I added that to the opinion, and you see that in your draft materials. And so the subcommittee thought that with that added provision of Rule 1.7, that the opinion will be ready for publication.
Thank you, Nicole. Evan?
Nicole did a great job of taking 12 or more questions that's in your materials and distilling them into the 4 questions that are in the opinion, so that it's concise and it's understandable. And so she gave us a great working draft, and we had a great meeting on December 8th, and I think Judge Langen was there, Tara was there, Kevin was there, and Fran was there, and we agreed that the opinion written by Nicole was correct. It correctly distinguishes between publicly available information and non-public information. It does cite the ABA rule and the former FEOs, and it really clarifies and lays out, what can and cannot be put in a confidentiality agreement. So I'll let the other members talk, but I'll make a motion that we publish.
Thank you, Evan. Kevin, Judge Langham, Tara, Fran, any other comments you want to add?
To shout out our subcommittee that we came to an agreement in 30 minutes.
Yeah. Are you bragging? I think you're bragging.
We owe that to Nicole. It was a very polished product that she gave, made our work very easy. I'm glad she included reference to 1.7 current clients. I know Tara and I were both concerned about that. I think everything about the inquiry about this imposition of confidentiality and settlement agreement just smacked of impropriety, but now we have a very clear directed. It wasn't as complex a matter as the overlapping billing. Not a whole lot of great. Nicole did an excellent job, and I would second that motion.
All right.
Nothing really to add other than I will say in the years on here, I think Evan ran the most efficient subcommittee meeting I've ever been a part of. So additional thanks to him as well as Nicole.
Well, it's nice to get a softball every now
You deserve it. Unlike Ernie and VR.
Earn
So, well, thank you all. Thank you for your efficiency. We'll just make sure that you guys just get reappointed to another little group. It sounds like good chemistry. So we have a motion to publish, and that has been seconded. Any further comments, questions? All right, all in favor, say aye. Aye. All who oppose? Motion passes. Okay, here's what I've been waiting for all day. So it's just doctor is what you can call me. So we have an inquiry of bachelor, which is our ability to use the title doctor. And Suzanne is going to...
I'm just going to set this up for you guys. We did not draft an opinion on it. We kind of just wanted to take the temperature of the committee and see what you thought. But we did receive a request for a formal ethics opinion modifying the guidance that we currently have on the permissibility of lawyers referring to themselves as doctors. We currently have 2 ethics opinions on this, RPC 5 from 1986, which says that lawyers may not call themselves doctors just based on their JD. And then we have 2007 FEO 5, which makes an exception and says that lawyers who are teaching in academia are permitted to use the title doctor, but only in that arena. Mr. Batchelor takes issue with these prohibitions, and he argues that anybody with a JD should be permitted to use the title doctor. So we have three options for you guys to look at. One is that we just keep everything the way it is. We keep the two ethics opinions that we have, which say a lawyer who is teaching at a college or in some other type of academic arena is permitted to use the term doctor, and that is the only time that a lawyer is permitted to use doctor. The second option is that we can get rid of both of those opinions and say every JD can use the title doctor whenever they want to. And the third option is to withdraw the opinion that allows the use of doctor in academia and just say nobody's allowed to use the term doctor. There's a lot of materials, interesting articles on this issue. There's a 2022 Law Review article that I thought was really informative, and they argued that it should be permissible. The ABA has basically said it's okay. The ABA says a JD is the same as a PhD. Texas and New Jersey have said it's okay, but only in academia. Kentucky has said that it is not permissible. The people that argue that it should be allowed are usually, they argue that the JD is equivalent to a PhD, and they feel like not being allowed to use the word doctor discriminates against JDs and disparages the degree, and that it's academic bullying. The lawyers that are against using a JD focus more on the misleading nature of the title doctor and feel like it's misleading to the public. So currently, North Carolina says you can use it if you are basically a professor.
What's the rationale in allowing that?
Because academia is so different.
Because they bully. No, I mean, they bully. I mean, that's what they do. Academics. I mean, it's title inflation. I mean, every academic I know, and I'm sorry if you're married to an academic, but they give themselves titles. I mean, every time I turn around, ECU, they got more assistant deans than I know what to do with. And they call themselves doctor, and I'm against that.
I was just wondering
Well,
why.
part of it is
But I am with keeping the opinion the same because, if everyone else is calling themselves doctor, in academia, I mean, by gosh, our lawyers should be called doctors.
And the other rationale is that it's not misleading. Your students aren't going to ask you to perform surgery probably.
Yeah, I didn't raise my hand.
I mean, everybody that's teaching is calling themselves doctor. It doesn't necessarily imply that you're a medical doctor, whereas if you're a lawyer practicing maybe medical malpractice and you call yourself doctor, there's a good chance that some people might think that you're a medical doctor.
Yeah.
So it just comes back to whether it's misleading.
So before we jump into comments, we have two people here who tentatively will be on the sub, Jay and Takia. I don't know if you have any comments before we sort of go to the other members.
Well, I know for me, it's not that serious, I just don't understand why it's necessary. I prefer to be called attorney. That to me is on the same level with doctor because, for my clients, that's the way they see it, and I can just imagine me calling myself Dr. Lewis Blaylock. One of my clients, they think I'm their therapist, so, they come in and say, "Oh, you're a doctor too," look at my arm, so I can just see that. So I don't think we need to do anything with the opinion.
Right. Jay, do you have anything?
I agree. 30 years I've been practicing, I never once thought about this. So, it's interesting reading.
Welcome to
Ethics.
Ethics.
It's interesting reading, but I think we ought to leave both the RPC 5 and the 2007 FEO 5 the same, in my opinion. I think it would create more confusion. If half of us started calling ourselves doctors, then clients are going to come in and say, "What's the difference in you? You're not a doctor, and the other lawyer's a doctor," and then it just starts. So
I'm a doctor and a specialist.
All right, so we had a lot of hands. I'm going to go back in order. Jack?
Yeah, I just wanted to know, Madam Chair, if we could take judicial notice of the fact that anyone who can define champerty and maintenance should be called whatever they want to be.
And the next person to comment is a judge who could possibly take judicial notice.
I will. So I just I agree that we should just leave it as it is. I, like you, don't see why this is so serious, but I also want to just piggyback on what you were saying, having come from academia, that is absolutely the reason why this is such a big deal to some people, because those professors who have those degrees, they want to separate themselves and elevate themselves beyond those who don't have those degrees. So they really are.
We call them elitists.
I was trying not to, like, you know.
I know we're publicly streaming.
I know. I'm glad you did it for me. Because I was trying not to. But I haven't been, like I said, in that world, had the experience of having been a clinical professor versus what we call a doctrinal professor, and they really want that distinction, those doctrinal professors. They see it as a big deal. We, though, we're the lawyers, though. We're the ones who actually are doing the work and in the field and, you know, all these things. And so I think that's where this is really coming from. I don't think there's a need for us to make any changes. We were having, I can't remember who I was talking to about this, but we were having a discussion about most people who are lawyers. When you're in the general public, you know, you want to kind of shun and not even be, you know, people know you're a lawyer. Because you don't want to open it up for like certain conversations already. So it's kind of like this is just going to add to it if it is, you know, implemented. So,
Wade?
I was just going to move that we leave it the way it is.
Okay.
I said.
Let me get a couple of comments. Evan?
Yes, and Bert was part of this conversation last night. We were talking to a resident Superior Court judge who is looking after his retirement to teach at a university. And the university is telling him he can't teach because he doesn't have a doctor. And he didn't know that this issue was coming up. And he didn't know about the prior opinions. But I'm not sure it's going to make any difference to this university that in academia he can be called a doctor. But I think leaving it the way it is the way to go. So if there is a chance this is a very talented senior resident Superior Court judge who would be a real addition to the criminal justice faculty.
We need to educate them. We are doctors of jurisprudence. We are.
But to allow that in academia would benefit the students and as well as the profession. So I agree with everybody. We just leave it as it is.
Yeah. Amy,
yeah, I was just going to say, I always come back to what our purpose is in this room, and it's to protect the public and not the lawyers. And the confusion created by calling us doctors is a disservice, but I think the exception we currently have in exactly what you just said, letting good lawyers be professors by using that title is a service to the public. So I think we have it right. I think we're doing our job, and I think this any alteration would not do our job.
Jeff?
I want to point out first that using doctor is not a title. It is a degree. The title is professor. There are only three basic ranks in academia, and we're four: instructor, lecturer at a level, and assistant, associate, and professor. Anything else you've got, professor is the biggest, the top rank in a university. So just using the designation is just recognizing they have a degree. That's all. It's not a rank. It's not anything else. That's what it is. I think it's very clear and helpful for that to be there. When I hired folks to teach business law, for example, I expected that they would be called doctor, and they, if the students wanted to do it, although I tried to tell them they should be referred to as professor anyway.
Thank you.
They also thought that having a doctorate was superior to being a professor.
Interesting.
The fact they were wrong was just a function of being lawyers, I think.
And you just said that publicly. Yes, as a public member, you said that publicly. So, yes.
Yeah, I would just add to the discussion that I think we've, as a state bar, already done a good job of striking the balance of interest between protecting the public versus allow a certain level of attorney free speech by our specialization rules and guidelines, our marketing rules and guidelines that we've set out. So we already have a good structure in place. I feel like appropriately acknowledging people who have achieved certain level of expertise in different areas, while at the same time protecting the public and making sure people don't run rampant claiming titles that they don't deserve and sort of thing. So for those reasons, additionally, I think we keep it as is.
Hypothetically, if I went out on campus in a quad, and I fall out and someone says I need a doctor, do you think anybody's gonna come out of the building? Or they're all doctors? No, because when you say you need a doctor, it's a medical doctor. And that's what we know. And yes, I'm digressing.
I'd like to wrap this up by pointing out the softball's been out there.
Yeah.
I'm always one to hit a softball when it's there, but I'm gonna support this motion despite the fact that it thwarts my lifelong goal to be Doc Savage.
So I'm going to translate your motion to say that you've made a motion to decline the inquiry of bachelor. Somebody else, Heidi, your motion.
We made a motion.
Yeah.
So I'm translating for our motion will be to decline the inquiry, which is the equivalent of leaving it as is.
Accept your reformation.
All right, so we have a first, and you had second, Doc Savage.
Can I make one comment?
Yes, please.
Because we're live streaming, I just want to be clear that not everyone that has a PhD wants to be called doctor, and I'm talking about my wife who has a doctorate in entomology and despises being called doctor and insists her students call her Kelly, but she does enjoy when we get stuff addressed to both of us as Dr. and Mr. Oaten.
All right, so we have the motion on the floor to decline the inquiry. Any further discussion?
And I'm being serious this time. This is serious. Mr. Batchelor, who I think wrote that, he spent a lot of time on this.
No, he did.
And I was very impressed about how it all came out. So when we try to, I don't know if the word's let him down easy, but I mean, instead of just saying no, I mean, if we could really maybe put in a couple sentences in there that we appreciate the time he took, because it was very informative.
That's why we.
So
that's why we presented
I was very
it to
impressed.
everybody, because our initial response was
It's a legitimate request.
we're not gonna do that, but we felt like he did put a lot of time into it. It was so we wanted to make sure that everybody had a chance to apply, and maybe we were wrong, and we weren't. So yeah, but definitely.
And it does kind of have a counterintuitive nature about it, right? Like when you go back and you look at the history of when they developed the JD, why they developed the JD. Well, if they didn't want to use the term Doctor of Jurisprudence, why did they develop the JD? You know what I mean? So there was a rational basis for the inquiry.
There's lots of articles on it. I mean, people talk about this more than you would think.
You're right. Just because we're declining, or I suspect we will decline, does not mean that it was not a valid inquiry. We probably could do a nice informal.
Yes.
As I learned from Marcy to Mr. Batchelor. So the motion's on the floor. Is everyone prepared to vote? All in favor, say aye.
Aye.
Any who oppose? All right, the motion passes. And all of you new members have survived your first ethics meeting. Thank you all. And if you have any questions or concerns, please let us know. And on your way out, please thank all the staff members because they do great work in making our jobs easier.